Okay, last thing today, we need to figure out some basic vocabulary terms that we're going to be using a lot. There's really no other setting in which we would just be discussing these, but as we go through different things that the court's done in the history of the court, we're going to be just using these words, and so it's important that we understand how they, what they mean and how they are used. So in the picture here, this is Justice Neil Gorsuch. He's one of our Supreme Court judges. He is what we call a textualist. We give him the vocab section because he is obsessed with the meaning of words, and that's how he makes his decisions about cases. So we'll end up talking about philosophies and stuff later, but Gorsuch loves words, so he's got our vocabulary section today. All right, first up, we need to understand some vocabulary that deals with different kinds of law. We'll be using these a lot. These are the three that are important to deal with, and the first two go together, and the last three don't really. But first, we got to make sure we understand the difference between criminal law and civil law. Criminal law means that a person has broken a law, like a person has committed a crime. A person did something that a law said they were not allowed to do. So in a criminal law case, the plaintiff in that case is the state, and the defendant is the person who broke the law. So like if I go out and commit a crime, the name of this court case is going to be Tennessee versus Kurt Rakestraw. Civil law is where we have a dispute between two people, like two private parties. So this doesn't involve the government, but two people want the courts to settle something. So if we have a dispute between two non-government people, that's would be what we call civil law. So like if I got in a lawsuit, maybe I'm going to sue Duval because she adopted Little Penny and Little Penny bit me. So that court case would be Rakestraw versus Duval. And that's a civil case because nobody broke a law. We're just asking the court to settle something between private people. So civil law and criminal law, got to make sure we can tell those apart. And that's pretty easy. Now, these other three are based on where the law comes from. So what we'll see a lot of, what we'll be using a lot is what we call common law. And that means that the law was created as a result of an earlier court case, an earlier court decision. So we call those precedents. We'll talk about precedent a little bit. But if the court decides in a particular situation, the court decides one way, that creates an example that's going to be followed by the court in the future. So even though nobody passed this law or whatever, we call this law, this is common law, because it was created by a court decision. Statutory law is regular policy, regular law we've been talking about so far. So if a law is made by a legislative body, like Congress, or maybe your state legislature, that's called a statute. That's what they call it. So when we see statutory law, we're talking about this is a law that was written by Congress. And then finally, we have administrative law. And this is what we were just talking about with the bureaucracy. So when a rule is made by a bureaucratic agency, that's called administrative law. So that wasn't written by Congress. That would be one of those details that was made by the members of the bureaucracy. So these are all our important types of law that we've got to understand. All right, let's also make sure that you've got a good understanding of who will be involved. And so we're going to call these people the litigants. The litigants in a court case, mostly the ones we're going to deal with the most are plaintiff and defendant. So the litigants are the plaintiff and defendant. The plaintiff is the person who decides to sue. The plaintiff brings a case to the court. In a criminal case, the plaintiff is the state. So like if I broke a law, Tennessee is going to bring me to court. That makes them the plaintiff. So the plaintiff has decided they want the court to act in some way. They have brought something to the court for the court to act upon. The defendant is the person who has a case brought against them. So in a civil case, that means somebody's got an issue with me, and I become the defendant in a case. Or if I was charged with a crime, I am the defendant there. I did not ask for this to be put before the court, but it involves me, and so I am trying to defend myself. So we've got the plaintiff and defendant. Plaintiff will always go first when we're listing the case, and the defendant will always go last. So like Tennessee versus Rakestraw. Tennessee is the plaintiff, Rakestraw is the defendant. The jury also consider a litigant. We're not going to worry about the jury too much, but another word I want to make sure that you know is counsel. Now, we've dealt with this way back when we were doing the amendments or whatever, but we'll see the word counsel, and we mean that counsel is a lawyer. That's what we usually call these people. But counsel means that someone was hired to speak on behalf of a litigant. So, you may have to go to court as a defendant, but you're not expected to be an expert in the law. So you can hire a person to know all that and to speak for you, and that person would be called counsel. So we have a Sixth Amendment right to counsel. We can always have the ability to get that service from someone who is an expert on the courts. All right, another very important concept for the courts in the United States is what we call justiciability. So justiciability means that the issue is an issue that the courts can make a decision about. That's the basic definition of justiciability. But let's talk about what justiciability means. So the courts in the United States are not just going to give advice. They are not just going to answer questions that come from other parts of a government. Like a state might want to ask, hey, can we do this? Or a branch of government might be like, is this law okay? And any of the courts do not give advice. They wait until there's actually a problem. Like a state may pass a law and then they wait until someone sues and says this isn't fair. So that's part of what justiciable means. There's aspects here. This gets into a little legal words here, but the issue must be ripe. That's a word. Ripe like a fruit. So that means that it's a problem that is existing. The courts do not deal with hypothetical situations. Like the courts don't answer questions like, could a person do this if they wanted to? Or does the president have the power to do this? The courts only rule on issues that are ripe, only rule on problems that are actually happening. So the president did this. Can they? And then the court would answer that. So that's the first step. The issue must be ripe. The other thing here, the issue cannot be what we call moot. Cannot be a moot point. So the court is not going to decide an issue that has already solved itself. Okay? So the court will not make a decision or even deal with a case that has already solved itself. So, it's tough to come up with examples here. But like if you were trying to sue, if you were a business owner and you were suing because the government forced you to close your business in March and April because of the pandemic. Well, if you want to sue them in July after they've allowed you to open your business up again, then the court's not going to answer that question because that problem solved itself. The last one here is tricky. And this is because the courts decide what they want to hear. They don't have to answer every question. And so one thing that the federal courts have said is that they will not answer what they call political questions. So if there's something that's just an argument between Democrats and Republicans, the courts won't really step in and answer that question. This has happened a lot with gerrymandering, which we've talked about, maybe one party draws district lines in a certain way. That's the kind of thing that a lot of times the court will avoid answering because the courts want to show that they're not a political party, that they're impartial. The courts want to show that they're independent from politics, and so they'll try to stay out of what they call political questions. All right, a few other terms that we'll see a lot that we'll throw around when we're talking about cases. Some vocab that deals with a case happening. The first one of those is you must have standing to sue. So here in the United States, a person has to have a reason to bring a lawsuit. So that means that our rule here is that the person must actually be involved. So if you are a person, you're like angry about a situation that doesn't involve you, you don't get to sue. We only allow people who are impacted by a situation to file a lawsuit. So the plaintiff who wants to file a case must actually be involved in the case. So let's take the very most important court case that you definitely know. Let's take Brown versus Board of Education. Okay. Now, Brown is the plaintiff there. They are suing the Board of Education because the family, and Linda Brown, she is harmed by the Board of Education of Topeka, Kansas. Now, if I were alive in the 50s as just an old white guy who lives in Memphis, I can't sue because I am not involved in that case. It can make me as mad as possible, and I can think it is unfair, but I'm not harmed by what is going on in schools in Topeka, Kansas. I'm in Tennessee, so it doesn't impact me at all, and so I would not have standing to sue. So for someone to file a lawsuit and to get it into the federal courts, they have to actually be connected to the issue. They have to be harmed, and that's the reason that they're coming to court. Another word that we'll use a lot is what we call a brief. And a brief is just a document that explains facts or arguments that happen in a case. So lawyers will issue briefs. We'll talk about some different kinds of briefs. If you are a person who you are mad about a case but you're not involved, you can submit briefs where you present your arguments and things like that. So briefs come from anywhere, but briefs are just documents that explain issues or facts dealing with a particular case. And then our last vocabulary term here, so important. We're going to be using this a lot. I already have, assuming that you guys know what it means, but we've got to make sure we understand precedent. So when we see the term precedent, we're talking about a decision of the court. And so this decision was made in the past, and that means for similar cases in the future, that's how the decision is going to be made. Okay, so precedent just means the court dealt with this situation this way in the past, and so if we see that same situation come up again, that's how we expect the court to rule. Think about that in class, right? If we were in class or whatever, and you came to class tardy, and I don't even know what I would do if I came to class tardy and I made you wouldn't let you use the hall pass because you came to class tardy. Then the next person who came to class tardy, we would expect that I would punish them in the same way. I would issue the same ruling. So the next person to come to class late, they also don't get to use the hall pass, something like that. That's what we mean with precedent. So a court has made a decision in a certain situation, and we expect if a similar situation comes before the court that they will make that same decision. All right, that's it for our vocab, and that's it for our first step into the third branch, the federal courts. So time to go over our big ideas from today. Here is President Trump shaking hands with Chief Justice John Roberts. So here's a couple of branches interacting as we get into what it is that the judicial branch does. Unrelated, here's President Trump getting to take a look at the Stanley Cup and meet a hockey team here who won the Stanley Cup. So here's what we want to make sure you can do after today. First, most important thing, you need to be able to describe what is in Article 3. There's not much there. Okay, so remember what is in Article 3, and you remember all the other things that are not a part of Article 3 as we go through courts for the next few days here. Also important that you are able to describe the impact of Marbury versus Madison. Okay, so Marbury versus Madison is our most important court case here, and we want to know how the decision in Marbury versus Madison impacted checks and balances. We want to be able to explain how judicial review creates a check on other branches of government. So judicial review, remember, that gives the court the ability to monitor and review the actions of other branches, and in some cases tell them no. If the courts tell another branch, you can't do that, now we've limited power. That is a check. And the other important thing here, because we're going to use it going forward, you got to make sure you know those random vocabulary terms. So don't forget those. We'll be using them a lot as we explore courts for the next few days. All right, guys, that's it. That is our first day into court stuff. This really, we'll be spending a few days talking about courts, but eventually we'll get into the decisions that have been made by courts, getting into what I really think is my favorite part of the year, when we get to study all that kind of stuff. So those of you guys thinking about a future in law, going to be an exciting couple of weeks here as we go through the court system and what they do. What we want to remember today, let's make sure we remember how little Article 3 says about what these courts are going to do, because we're now going to spend the next few days talking about all of the important roles that the courts have.